So now we will move on to Biyan Mienert, who will share his thoughts on whether any regulation of DAOs should foresee or should provide for any limited liability or a legal regime which replicates the limited liability rules and structures that we already have in place for other entities such as companies. So, Biyan, please, the floor is yours.
Okay, now, so thank you again for the introduction and for the invitation to speak here. It has been some great discussions and great presentations which covered a lot of topics, and I just want to now go deeper into the topic of limited liability as applied to DAOs and go through a couple of points there that I have here as an intro. First, what is the main idea that we are looking at? What is the main question? Then where does the idea of limited liability in the first place come from, like applied to traditional business entities? And then what could be the consequences of limited liability as applied to DAOs, like the advantages, and how such limited liability could finally be applied through lawmakers or through courts, and what kind of challenges have there. And we already heard a lot of different cases and precedents there. Therefore, I just want to touch that briefly and conclude with the final thoughts on that topic. So first, the introduction, and we heard that a lot. We have a totally different organizational structure with DAOs that we are looking at. And if we look at our corporate law and how it has evolved, especially in the Romanian law and the common law space, it always developed either through artificial making from the lawmakers, or it developed itself in the free markets and then were just put into a legal frame from lawmakers. And so the main question that we're also looking at with limited liability is if DAOs can fit into that known legal structures that we have, or do they require a full change? And we already had some ideas in the first panel and discussion that some are against a full new structure, some before. So I want to give my thought on that later, but I think it's a core discussion to have with that kind of topic, as it's a whole new idea how people can work horizontally together. So the first idea is to take where does limited liability come from in the first place? So limited liability, while it's now a very important feature of modern cooperation, has not always been an attribute of cooperation. It evolved over three periods of time, from the 1600s to the 20th century, where really the limited liability was applied in the 20th century, like it was only in the third period where creditors were granted legal priority over equity holders in claiming corporate assets. And so to think of, and I think that's also crucial in the case of DAOs, where does the idea of limited liability come from, and what are the economic and legal reasons for that? So with the growth of large and complex corporations in the EU and also in the United States, there were a big difference between what shareholders could monitor when they would invest into a business and what would actually happen in the business. So as shareholders then, with big corporations, big stock companies coming up, lacked the power and control mechanisms to oversee everything what could happen within this organization, limited liability become a key feature. So investment was still interesting, and investors could invest all in different businesses without having to monitor them, and they would just have the risk of the money they put in. And also on the business side, it allowed businesses to work in a different way than before, because they would not have to monitor everybody who was in that space or who was working for that, and they had this kind of protection over their business, which could just hit the business itself, but not the persons behind it. And so this is really a big, something happened to my screen, but I can maybe share. No, okay, I will share it here again. So just to continue on that point, if we look now at DAOs and where the idea of limited liability or personal liability came from, so in traditional organizations, we still had the personal liability in partnerships, and we had the liability of the board members for certain reasons. But with decentralized structures, it really if we look at the idea of partnerships, and as we heard before, a lot of lawyers are of the opinion that most DAOs qualify as general partnerships. The decentralized structure kind of calls into the question the effectiveness of this personal liability, which comes with the general partnerships, and also the security and behavioral liability that comes with that. Because in a decentralized organization, management responsibility is distributed among the hardly manageable group of members, which leads to an extensive devaluation of liability as an effective means of traffic and creditor protection and behavioral control. So I think this comes to the point that, as we have seen before in the history, that when there was a new type of organization or a new market evolved, lawmakers adapted to that and it included this idea of limited liability. And I think this should be the same case in DAOs, that we adapt to these new organizational structures who kind of opens up a way how we can provide, on the one hand, creditor protection, but on the other hand, give limited liability to this new structure to develop. And therefore, we come to of course, a lot of new points and benefits that come with limited liability for DAOs, which is, of course, encouraging innovation and risk-taking, also attracting more investors and contributors, especially as Professor Möslein mentioned before, with the cases in the US, it scares a lot of contributors and a lot of investors to get involved in DAOs because just of the legal challenges. I remember when I first started in the space and with DAOs in 2016-17, this legal risk was way lower and it wasn't really thought about. But we now see with the launch of DAOs, and I also see that in my day-to-day work, there's a lot of legal engineering what goes into that. And before it was just we launch a DAO and look how it's going to go. But now there's a lot of legal engineering and thinking behind it, how to work with that. And so I think it would also make sense for this whole space if we could create some kind of legal certainty and align DAOs with the existing legal frameworks or put them into that. So if they choose to incorporate and use that structure, then they are within a certain legal framework and requirement what they can work with, and which is clear for contributors and investors on that point. Now, as we've seen the benefits, of course, the question is how can this limited liability applied, or what are the different ways to apply that? And first, of course, there are a lot of challenges that we will probably hear also later about, especially determining the appropriate jurisdiction for DAOs, because if we look at international private law, and if we have a full decentralized DAO just without any incorporation, it's quite hard to determine the applicable law. So this is one of the first challenges, that if there's nothing on-chain like a participation agreement or anything else which chooses a governing law, this could already be the first big issue. The second thing, of course, is that from our traditional thinking in corporate law, limited liability mostly comes with defining and identifying members of that corporation and their roles. And this is a big issue with DAOs, where we mostly have anonymous or pseudonymous contributors and workers within that. So the goal really is, or the challenge is here, to balance anonymity and transparency in the context of limited liability. And there are different ideas how it could be done. Of course, first there's the solution of creating a new legal entity, especially for DAOs, which I think makes a lot of sense, because the narrative that we have is very different than from the ground or from the first ideas that we have with corporations and how they were meant. So I think it could create more problems in the long run if we adapt existing limited liability structures to accommodate DAOs, especially in our Romanian law circle, as we compare our limited liability corporations to US or common law structures. They are not so flexible. If we look at, for example, the common law LLC, it is way more flexible than any potential limited liability corporation structure that we have in the European law circle. And I think this, as we mentioned, Mika, before, this should be something which happens on the European level, and introducing a new corporation on the European level, like we had with the European Cooperative Society, the SCE, and also the SE, and which the SCE is not that widely used, but the SE is widely used by the law corporations. And I think this should be something which could, the European lawmakers, which they could really push and go towards a direction which, the same with MiCA, creates legal certainty and gives the possibility to make Europe a hub where this kind of decentralized structures can flourish in a safer, certain way than they have in the US. And there are different approaches how this could be done. And unfortunately, Silke is not here, and all the best to her, because she worked with together with the model law from the Koala Association, where they kind of showed how it could be done. And I think it's a good base. And there are different problems that need to be solved when creating this new type of legal entity. And I think the main issue of course, is that the specific risk that decentralization creates and anonymity creates is to have some kind of creditor protection for everybody who interacts with the DAO. And this topic comes up a lot, and people are discussing different points, from having a mandatory insurance, for having an independent liability fund for organizations. There are a lot of different ways to manage this and to think about this. And I think that that mandatory insurance could be a topic, but it also creates some economic problems in the long run. How are these insurance going to look like, and how can they be fully structured when they are cross-chain borders going all over the world? There are already some providers like Nexus Mutual who provide like insurances for DeFi protocols. But I think in the case of DAOs, mandatory insurance would create too much problems in the long run. And how do you monitor and register it? And also it would create, again, some kind of centralization point, who is going to sign the insurance, how it's going to work. So I think it makes more sense to have every DAO which gets some kind of limited liability structure to have in their treasury, which most DAOs have, to have some kind of liability fund. And it's comparable to the liability structure that we have with limited liability companies at the moment, that they have some kind of mandatory capital within the company, let it be the German GmbH who has 25K or anything like that. I think that would really make sense. And in difference to the common companies that we have, or legal structures that we have with DAOs, it could all be monitored on chain. So it could be seen that there is some potential also for creditors and potential investors, or even contributors. Everybody could see, okay, there is this tag liability fund where this kind of money is in, and then investors can kind of think, or creditors can think how they want to interact with that DAO. And I think that makes really sense. And a lot of DAOs, I know that from my personal work, already have that established. And we saw that in the last 2 years really accelerate that. We saw a lot of proposals with different DAOs looking for general counsels, setting up legal liability funds, and these kind of types. I think it makes really sense to have that minimum capital, some kind of capital contribution control, and capital preservation regulation for DAOs in that case, as we have with other limited liability structures. On the other hand, I think we also should not put too much pressure on this structure, because if we think of a lot of common law limiteds that's just have $1 mandatory capital, there's always for the creditor, or anyone who gets in a contract for them, the risk, and they can't even see their full funds on chain. So I think we should have a good balance with the different approaches here. The model law I mentioned, there are some good ideas that there's certain liability for everything for the contributors providing on-chain contribution they have committed to the DAOs, and that members won't be liable for obligation incurred by the DAO. But if they vote again for some criminal actions of the DAO, they could be liable in that cases. And I think it's good to find some kind of balance in that space, where we manage creditor risk, as I mentioned before, and the full possible decentralization of these structures. And to come to the close here on that point, I think we need to have a limited liability to DAOs who does not hinder the decentralization, because most structures and how corporate law developed, it always came that limited liability came with a very centralized structure. Because if we look at the most decentralized structures that we have in corporate law, they all have personal liability, like a partnership or in corporation or in some other type of like kind of more fluent corporate types. So I think we could, to give a concrete example, use the Koala law, and for our legal circle, we should try to adapt some points of the LLC to use in that idea. And if we look at what lawmakers did in the US, like the Wyoming DAO law and also in Vermont and Utah now, the idea was good, but how they actually did it created more problems than it really solved for DAOs. And we see that I don't have any clients who used the Wyoming DAO LLC because it creates more burdens than it creates benefits for the DAO. For especially if they want to incorporate, they still use a Delaware LLC over a Wyoming LLC because it's way more flexible. But it still comes with the downside that every member who wants to really be wrapped is kind of mentioned in the documents. And we see a lot of DAOs use foundation structures, also used a lot of Cayman Foundation company, but the problems always or mostly with the foundation structures is that they don't really wrap the DAO and protect the token holders, right? So we really need something in between that who can create that decentralized protection for DAOs in that case. And now we heard a lot of different case studies and precedents. I just want to mention some kind of ideas which I think is going to the right direction. And you already mentioned the Marshall Islands and Adam from MeDAO before. I think they're doing great work on that part, that they open up some kind of legal structure for nonprofits DAOs. And as to my knowledge, they're also working of having the possibility to establish for-profit DAOs there and have the kind of limited liability in a very decentralized way. And these small offshore jurisdictions, I think we can, as they kind of go for trial and error, we can take a lot of lessons that we learn from them and see how it works from them, trying to adapt that to our European law level and incorporate some kind of European law structure which helps with that. Because we see the US move kind of fast, although on a federal level, it's for the different states, there are a lot of states who are very pushing that topic, but on the whole, the US is very hostile at the moment for crypto projects, which doesn't really help. And I think we can use some kind of flexibility that we see there and learn from the lessons or the downside that we saw there to incorporate after MiCA now a new European structure who would be open for decentralized protocols. And I'm still of the opinion that there is a way for unincorporated DAOs to operate. Of course, the Oki DAO case created a lot of tension and a lot of history and fear in the whole DAO space. But I still think fully decentralization until there is some kind of new legal structure who enables that is rarely impossible with some kind of legal wrapper. So I still think for some DAOs, if they are fully anonymous and fully want to do everything on-chain, I just mean on-chain agreements. They can use just on-chain agreements, and we saw that a lot with different DAOs. So everybody has to sign like a participation agreement when voting, and kind of limit the liability in that kind of case. And so there could be a governing law applied. We could have some different arbitration clauses, which could make sense. So there's a way to work around that if you don't want to incorporate, I think, and which could still make sense for some DAOs. And that's when I want to close with my conclusion is that, of course, I see a lot of benefits of applying limited liability to DAOs, but I don't think we should do that just for the sake of that without thinking through the legal structure, because we already saw that, as I mentioned, with Wyoming, then just kind of putting the name DAO on the legal structure that we have doesn't really help and solve the problem, because it just creates more boundaries for this kind of new organizational structure. And I think history has shown that it makes sense if new structures develop over the time, that the law adapts to that and gives them the possibility. And as the GmbH or the limited was artificially made by the by the lawmakers, I think the same should be done for DAOs, and there should be an encouraging dialogue between DAO members, contributors, and lawmakers to really have something which could work there and then create benefits on the both sides. One, more legal certainty for DAO members, contributors, also more legal certainty and risk aversity for creditors who can basically then work with the DAO in certain ways. So I think that really makes sense. And I think the topic of limited liability is a big issue that we need to solve to really push that space to the next level and attract more and more investors and contributors. Thank you very much. I'm open for any questions, and also in the afterwards, anyone to write to you and write to me, and also my PhD about DAOs, where I cover a lot of topics, is freely available, which everybody can access. So if anybody wants to read that, then I'm also happy about that.